Julia Keough. Terry. Nice to meet you, Terry.
You good, how are you?
Nice to see you, Representative.
Nice to see you as well. How are you? Well, good afternoon. I would like to thank everyone for being here, and a special thank you to Governor Baker, Lieutenant Governor Polito, and Secretary Reidy. We're here today and to welcome you to this vital conversation around legislation that will help to keep our communities safer around the Commonwealth of Massachusetts, to discuss dangerousness and SVEM legislation. Both dangerousness and SEVM are vital to help survivors within this community and communities around the Commonwealth to have enhanced safety and increased offender accountability. I would like to turn the floor over now to Governor Baker.
Thanks, Sandra. I'm going to be very brief because I'm more interested in what the folks who are here today, and I want to thank you very much for joining us and for giving all of us a chance to hear your stories. I do think that we have a real opportunity to do some things with both of these initiatives to make our communities safe, and especially to speak to many of the victims and survivors for whom these issues have been a critical piece of their experience. And with that, I will turn it over to Lieutenant Governor.
Great, thank you. Good afternoon, everyone. And Sandra, thank you so much for your advocacy and for bringing us all together. I do also want to thank Secretary Reidy and the ops team, Laurie Myers and others, for reaching out to each one of you. And most importantly, thank you for sharing your stories, not only with Governor Baker and me, but to the broader community. And it's a difficult moment for you always to think about what happened and now to share it. I want to thank you because you're going to help others feel empowered that are in vulnerable situations. The one area, in addition to dangerousness, we'll be talking about is the sexual explicit visual materials. Massachusetts lags behind. 48 other states have better laws than we do regarding what is commonly referred to as revenge porn. And as a mother of two teenagers, in seeing how much they communicate and share with their devices, it is critically important that we better protect them around what happens with a sharing of an image, and if it's used without their consent to harm them, harass them, or embarrass them, there should be consequences for that, as well as closing a loophole here in Massachusetts where adults who do that can be prosecuted with a felony consequence. So there's a lot more work to do, even though I am very proud of the work we do as part of the Sexual Assault and Domestic Violence Council for the governor. We've made a lot of progress in this state, but we know that there is more that we can do in these two areas. And by your coming forward today and sharing again, we hope that this will be a priority of the legislature and we can close these loopholes and make it safer for the people and the youth of this Commonwealth.
I would like to turn it over now to Representative Sullivan.
Thank you. Good afternoon. I first want to start by thanking Governor Baker, Lieutenant Governor Polito, Secretary Reidy, and Sandra from Shore Resource Center for hosting this roundtable and this event this afternoon. I also want to recognize Karyn Polito from Shore Resource Center and Julia from Health Imperatives for also being here. I am State Representative Allison Sullivan, and I am a survivor of domestic violence. I understand firsthand how critically important an act to protect the Commonwealth from dangerous people is for victims of domestic violence. Like other victims, I suffered over a long period of time severe physical and emotional abuse from a very dangerous and manipulative person. Also, like other victims of domestic violence, though my abuser was arrested and charged with serious offenses that allowed for him to be held on a dangerousness hearing, I was not, at that moment in time, emotionally capable of confronting the abuse or my abuser. However, unlike many other cases, my abuser was classified as a Safety First program, which is a program within the District Attorney's Office to identify high-risk offenders. This program notifies the Assistant District Attorney, who may be prosecuting the case, that the defendant is a violent and dangerous individual and at high risk of reoffending. I was lucky, and what saved my life is that he was so well known to those prosecutor's office and to the local law enforcement as a violent and very dangerous person. Notwithstanding how much progress we have made and how many resources the DA's office has, through the numbers alone, we recognize not every victim of domestic violence is afforded the same services and intervention. Like things like caseloads of individual prosecutors, not having a high-risk assessment team within the District Attorney's Office, offenders offending in multiple jurisdictions, and offenders' ability and experiences in manipulating the system impact outcomes. In my case, my offender was held through a dangerous hearing thanks to the extraordinary efforts of law enforcement, the commitment of hardworking prosecutors, the courage of a lifelong friend, and unwavering support from family. Notwithstanding my ability to assist, the prosecutor was able to move for a dangerous hearing and at my abuser's arraignment. You talk about the stars being aligned, even though I may not have seen it at that moment. My abuser was rightfully held to his dangerousness pending his trial, which I truly believe saved my life. Two important things occurred as a result of my abuser's detention. First and foremost, I was safe. And second, I began that journey from victim to survivor. But for my abuser being held, I sometimes think what might have happened to me if he was not held to his dangerousness, and when I do not picture where I am today. This is why I support the refile of this very important legislation. It enhances the tools currently available, but oftentimes not capable of being used by law enforcement, prosecutors, and the courts. This bill allows for evidence to be developed even after an arraignment that could be used to prosecute or to move for detention. We know violent situations occur suddenly. Victims suffer both physical and emotional severe abuse. Many, like me, are reluctant, fearful, or clinging to some hope and might be unable or incapable to fully share their story or provide necessary evidence to establish an abuser's dangerousness. Sometimes law enforcement and the prosecutors need time to develop this evidence. Victims should have the benefit of the prosecution no matter when the evidence of dangerousness is determined sufficient. This bill is critically important so that the victims of abuse can be protected from dangerous abusers like my abuser. Prosecutors and advocates need all the tools we can provide to help protect victims of violence from dangerous abusers at the earliest time or during any point during the proceedings. This bill is that tool. Sadly, history shows victims of this type of violence are at greater risk of being harmed when they seek assistance and when they try to leave. We need to protect victims. I am honored to be with all these brave women, survivors, whose stories are powerful and most certainly need to be heard. They too suffered violent encounters from violent, dangerous people. I will now turn it over for their remarks. Thank you.
Thank you. My name is Sherry Boone, and I would like first to start off by saying thank you for coming out here today and listening to our stories. My story began on November 4th of 2017. I'm a survivor of mental, emotional, and physical abuse. On that day, I almost lost my life from an ex-boyfriend of mine who stabbed me several times in the chest and abdomen, all because I didn't want to get back together with him. He stabbed me in my vehicle, and from that point going forward, I was in for the fight of my life. It was either fight or flight mode. I left the scene gasping to breathe and drove away as I called 911. I still don't know how I drove away other than thinking of my kids and my grandsons, and I was not going to let him get to them. I was only able to drive a short distance while I was on the phone with 911, my vision started to become very blurry as I was losing a lot of blood. The police, EMTs, paramedics got to me and eventually got me stable enough to med flight me from there to Mass General. I was brought into surgery, which lasted approximately 10 hours or so, and I died 3 times on the table. But fortunate for me, I had a great team of doctors who saved my life. I ended up in ICU, where I stayed for 6 days or so, and then into a regular room. While I was there, they let my 3 kids come in to see me. They saw me with the breathing tube, lots of IVs, and other tubes as well. It was days before I could acknowledge that my kids were there to see me. Boy, was I happy to see that they were all okay. Well, at least physically. Emotionally, that's a different story. Over the past 4 years, I have had 5 surgeries and will be on medication for the rest of my life due to the injuries that I sustained from the hands of my abuser. My abuser was held in Plymouth House of Correction from the day of the attack, and then that Monday went to court. My children went to court as well, whereas I wasn't able to be there. They wanted to make sure that he was going to be held in jail as they were frightened for me as well as themselves, that he might try to get to us. So that day in court, they stated they were going to have him come back in a few days and they were going to do the dangerousness hearing. So he went back to jail and then came back on that Friday for the dangerousness hearing. And he ended up being held 180 days on that, as they stated he was too dangerous to be let out. He was also given a no contact order, and thank God for the hearing. At least I could feel safe for those 180 days. After that 180 days, he was granted bail, but fortunately for me, he was not able to pay. And he was held until the case was finalized, despite him filing a motion to have his bail reduced, which he was granted, but again, fortunate for me, was not able to pay the bail that they lowered. And again, I just want to thank everybody for coming here today and listening to our stories.
Thank you.
That had to happen. Thank you for hearing us today. My name is Jen. My story is very different from Sherry's, but I feel it's important to share. So I am a survivor of physical, sexual, emotional, and financial abuse. The monster I became involved with had a very long record of violent offenses against both men and women, dating back to his age at 16. We were both 33 at the time we started dating. He had been charged and convicted in the past of intent to murder, armed robbery, assault with weapons on men, and several women prior to my even meeting him. His violence began and continued towards me shortly into our relationship. We met in February of '04, and this continued through February of 2013, when I chose to fight him out of my house in the fight of my life, when I decided that I would rather be dead than continue. I only found out after I got away that Monster had beaten another woman almost to death in 2008 and was given an extremely low bail and 2-year suspended sentence, as well as weekly probation. Additionally, the Monster had shattered another woman's leg in 2010. He later verbally threatened both of those victims in 2013. Monster lost all 3 of the restraining order hearings he tried to prevent, including a restraining order while on house arrest for violating my restraining order, as well as the conditions of release and probation while wearing a GPS. Never once was he held for a violence hearing with any of us. With direct regard to my situation, Monster was arraigned in Plymouth District Court, Plymouth Superior, Quincy District, Falmouth District Court, Norfolk Superior Court, and additionally, we had a case in Providence, Rhode Island. I have been told that my case was not typical in the amount of severity and abuse I endured, but I do know that it was preventable. Had Monster been held in a dangerous hearing at any of the 5 arraignments he had while with me, all without my knowledge, he could have been stopped. My own physical abuse and resulting long-term injuries could have been avoided. I have ongoing surgical procedures as a direct result of his injuries, including procedures to help with damage to my throat from strangulation. My voice has actually completely changed. With regard to my frustration, the defendant not only showed no remorse at each arraignment, but got increasingly angry. I had to deal with him sending people to harass me, threaten me, chase me, leave dead animals in my grill and at my door, and many more threats and phone calls. All of this substantially wounded my teenage daughter emotionally and, of course, me. The defendant was given average to high bail, I was told, on each case, up to $15,000 on most of them. He was put on GPS monitoring with exclusion zones, stay-away orders, and more, and yet somehow he always managed to pay his bail, always managed to get straight out, and he violated his restraining order against me twice, conditions of probation and release multiple times. He was ultimately sent to both Dedham and Plymouth House of Correction at least 3 times by probation just for violating his terms of release. While on house arrest, he went to a hotel instead of court while on GPS house arrest. He has no regard for the law, rules, or regulations, and he is done serving his multiple 5-year on and after sentence and is now doing 5 years of probation with GPS, anger management, and some other conditions. Yet he has still made it clear he will kill me. There is no excuse the state can give me why from 2013 to now I am still in a nightmare of harassment and excuses. He has 88 felony convictions, multiple misdemeanor charges. There are 2 lifetime restraining orders against him and another 10-year by 3 separate victims. I feel all of this was avoidable had he been held for a dangerousness hearing. Every person I dealt with in the court system saw his record and charges and could not express how dangerous they felt he was. He tried to kill me more times than I can count. I suffered a broken back, arm, crushed hand, concussions, and ongoing throat issues from being strangled. My body wears the scars of an abused woman, yet I feel more abused by consistently having my life at risk while the court system really did nothing of substance to stop him. He also was convicted on every charge and/or pled guilty to the rest. I can only show you the physical damage and not the emotional. I ask you to consider, though, back in 2008, when the defendant had beaten another woman almost to death, if he had had a dangerousness hearing then, would I still have suffered his brutal sexual and physical abuse? There's a good chance that I could have been saved and the defendant could have been stopped there. Instead, the same thing happened in 2010. He continued to beat me, and as his record shows, others as well. There were many times that a dangerousness hearing may have saved me. Instead, for the next 2 years, I will still be advocating for myself each time he wants to travel or do something that involves his probation. And I do it knowing that every time I see him, I relive my 9 years of being terrified, and I know likely he will keep his promise to kill me. I appreciate your time and thank you for hearing me today.
Governor Baker, Lieutenant Governor Polito, and all those in attendance today, thank you so much for taking the time to hear my story. Research has shown that the risk of domestic homicide becomes highest during the period of separation. On 6/15/2019, I took out an emergency restraining order against my abuser. He was arrested and bailed several hours later. I asked the police officer how he could be bailed after he strangled me, attempted to smother me, sexually assaulted me, all while I was breastfeeding our 7-month-old son. The police officer said he's had no prior convictions. I was granted the emergency restraining order, and I was so grateful, but I knew that no piece of paper was going to keep me safe. At that point, I took my children to my parents' house, and this is where we have stayed for the last 914 days. My children and I were completely uprooted from the home we shared with my abuser. We left everything behind, and I never could explain to them what really happened, just that we needed to be safe. 6/15/19 was the last time I let him put his hands on me, put his hands on us. Every time was worse than the last. It started with him throwing things, punching things, breaking household items, ripping up my belongings, taking my phone, throwing my glasses so I couldn't see anything, yelling, screaming, belittling me, calling me names, taking my money. How could the police tell me he wasn't dangerous? No one knew what this man was capable of. That Monday, June 17th, 2019, I went to the court to extend the restraining order. The judge granted the restraining order for a year and ordered my abuser to a GPS monitoring bracelet. I finally felt like I could take a deep breath. I remained fearful, always waiting for something to happen, but the GPS helped me feel more secure. On June 14th, 2020, I got a message from the GPS monitoring company that a warrant had been issued for my abuser's arrest, but no explanation as to why. It was approximately 2 a.m. and I was sleeping. They left a message. It was the weekend, and I had to wait until Monday afternoon for an explanation. So all weekend, I feared for my safety, and again, it felt like I was back to square one. The police could not divulge any information to me or even tell me if my abuser had been located. I later found out that he was taken into custody and his ankle strap had come loose. I didn't understand. Did he try to remove it? Where had he been the entire time he was unaccounted for? Was he going to set my house on fire or blow up my car like he had threatened in the past? The police told me he wasn't dangerous. On Saturday, March 13th, 2020, in the middle of the night, the police were banging on my door. I answered the door while holding my son. I had no idea what was happening. They asked me if I was safe. I was so confused. The police informed me a warrant had been issued for my abuser. But why? Again, they couldn't tell me. I begged for answers. They told me it was confidential. I was so scared. On Monday, March 15th, 2020, I was notified that his ankle strap was loose again on his bracelet. Again, I was told that since he had been compliant thus far, it was unlikely he did anything intentional to remove the device. All I could think about was, where was he during the time he was unaccounted for? This is the man that had no problem trying to kill me while holding our son. But I was told he wasn't dangerous. My abuser would threaten me almost daily that he would kill me, that if I ever tried to leave him, he would take the children, he would set the house on fire, he would torture me. Who is determining he's not dangerous? On March 31st, 2021, the GPS monitoring device was removed by the courts. I am told because he wasn't violent during that time that the bracelet was on, he hasn't had any offenses, that they could remove it because it was interfering with his job. His job being a paramedic, mine a nurse in the emergency room. So now I'm back to worrying if he's going to show up at my work yielding a patient, looking to speak to me and stalk me. Again, how is he not considered dangerous? It has been 914 days since I have been away from him. It has been 914 days since he has seen our son. On October 23rd, 2021, the DA's office informed me that the case would no longer be prosecuted. Who's rooting for my safety and my children's safety? When will we be set free?
I just want to say thank you for the opportunity to be here today. If my story helps one woman, then all of it was worth it. It can happen to anybody. I could be your daughter, your sister, your friend. If my abuser was held because of dangerousness, then he would have never gotten the opportunity to repeatedly stalk me, break into my home, strangle me, kidnap me and my baby. He would have never been able to find out where we relocated on a domestic violence voucher, but he did, all due to the DTA sending my change of address to his house. He wouldn't have been able to hold his 67-year-old mother hostage and try to thumb her eyes out, resulting in 2 black eyes. If this bill had passed, my abuser would have never been able to break into my home on November 7th, attack me, break 8 of my teeth, and rip chunks of my hair out. This bill would have made it so that our paths would have never crossed. He has a record with all violent crimes, including first-degree murder, escaping prison, kidnapping. If this bill had passed,
my 2 older children would still be at home safe with me. But they're not. They're with my ex-husband because my home isn't safe. Feeling safe is a basic human right that everybody should have. It's not a lot to ask. My abuser has had GPS on and cut it off multiple times. At one of his dangerousness hearings, he assaulted his own lawyer and court officer. Nothing is more horrifying than thinking he is incarcerated and you're bringing your groceries into your home and you turn around and there he is without any warning or notification. This is so important to me. It is a tool to assist the prosecutors, advocates, and the police because they are the ones fighting for us. Out of all the calls I made and all the times I advocated for myself, one person listened to me after 6 years, and it was Karyn. And it means a lot to be heard. It means a lot to know that other people value your life. My life isn't less important than anybody in this room, you know, and I just want to be able to raise my kids in peace. I was an advocate for mothers getting their children back, like babies born addicted. I've been in recovery for 10 years. I never used over this, but I do have complex PTSD that makes me stuck. I have to relocate and I have barely any help with that. I'm a mother. You know, my life matters to my 3 children. And everybody here, you know, I'm honored to be sitting with these women because no matter what, like I feel like we are the toughest out of everybody. We have dealt with war zones in our home. We have dealt with loving somebody that could kill us. That is not normal. You know, I'm really honored that Karyn asked me to be here, and I'm honored to be sitting next to all of these women today. Thank you.
Okay, sorry, I just need to gather myself after hearing her say it. Thank you, Governor Baker, Lieutenant Governor Polito, Secretary Reidy, and everybody else for listening to all our stories. I hope sharing my story of physical and emotional abuse and the horrible experience of being trapped in our unsupportive justice system will prevent others from my experience. Victims often suffer not only the abuse of their abuser, but the lack of respect and dignity given to them by the system, which in turn gives the defendant many rights and exits to avoid punishment. Laws need to change to protect victims. I implore you to use your power to make change by supporting this bill presented to you today. My ex-partner hit me, spit on me while screaming at me, threatened the well-being of my children. Our fear of him will be forever. He had multiple restraining order violations and probation violations, including lying to probation. Yet his credibility in court seemed unwavering. I learned perjury is ignored. The laws in place, however, silence me from addressing the court to defend or protect myself. While on probation, he assaulted me for the 2nd time. It was as if each violation was his first offense, and he continued to get chance after chance after chance, rather than his extensive history being heard and considered at each hearing. Yet I'm the same woman being abused and trying to live safely while also being re-victimized by the system. While on probation, my abuser cut off his GPS. He lied and said a TSA agent did it at Logan Airport. The TSA Director of Security told probation that this story was ridiculous, yet probation accepted it. The Hingham Chief Probation Officer actually told me they know it was done by TSA because it was a clean cut and done with, I quote, special scissors. I couldn't believe this. I couldn't believe that probation now was failing me. I contacted the Commissioner of Probation in Boston and relentlessly fought for the truth and begged for protection. An investigation was finally done, and it was proven he cut the GPS off in a parking lot with pliers. At the probation hearing, a judge did not punish him, nor was his probation extended. The message received, more chances to hurt me, my protection gone. He is empowered, probation failed. In one hearing, his attorney told the judge, Your Honor, my client only open-hand slapped her across the face. I wanted to yell no. He's done so much more to me than that, but yet I stood silent again. Even after this admittance by his attorney, he did not get a guilty sentence for assault. As he stood in his blue blazer, the corporate man, the judge said it would ruin his career. No accountability, no boundaries, no fear of punishment. His behavior continues today as I continue to navigate our broken justice system. My life and my children's lives are changed forever. I hope you will share with us the need and the passion to pass the provisions of this dangerousness bill and give victims a voice and protection we all need. I implore you, again, to make cutting off a GPS a felony, along with other provisions of this bill to protect victims from their abusers. We all deserve safety and peace. Thank you very much for listening to us.
Thank you for asking me to speak today. I'm here because I was attacked and sexually assaulted 33 years ago by a serial rapist. I was 23 years old at the time, visiting Cape Cod for Memorial Day weekend, and one night my friends and I got back to our motel room and realized we were locked out of our room. I offered to go up to the front desk and get a key, and when I got up there, a man grabbed me when I was telling him what I needed, and started dragging me to a wooded area on the side of the motel. I resisted and started screaming, and he threw me into a retaining wall so hard that I literally saw stars and was just in disbelief because no one had ever intentionally harmed me in this way before. I tried to talk him out of hurting me, and that didn't really seem to work, and I realized there was really nothing I could do to prevent his assault because he was so much stronger than I was. When he was finished, he told me to put my clothes back on and told me that he was going to keep me, and he was going to keep doing this to me. He grabbed my wrist and started to drag me across the street toward a parking area where his car was. And as we were crossing the road, there was another car coming down the street, and I just pulled away, ran in front of it, and luckily it stopped. And someone jumped out and helped me to escape. I was really lucky that I was able to get away from him, and it wasn't easy, but with the support of my friends and family, I decided to report the crime and then worked with the police for about 2 months looking for this man because he was continuing to assault women in the community. The police discovered a common factor, and that was that most of the women that he had attacked had been at the same bar that evening. So they started, I went with them to that bar, and one night we were standing outside, and I actually saw him standing there. It was amazing. So they arrested him, and when they took him in and looked at his background, they discovered that he was out on bail because he had raped someone a year ago, the past June, and was free for a year to walk around sexually assaulting unsuspecting women like myself. So that was in May of 1988, and that was the beginning of my 30-plus year journey of living in fear, and it was the end of my naivety. For a long time, I could only sleep knowing that my brother was in the room with a hunting rifle under his bed and a knife between my mattresses. I was convinced he was going to find me, and because he was a stranger and someone I didn't know, I was afraid of anybody that I didn't know. I no longer could trust our system to keep dangerous people out of the community. My biggest fear was that he was going to come back to punish me for putting him in jail. And many of the decisions I made during that period of my life were centered around keeping myself safe. In 2009, I was informed that he had been released. On that day, it was like stepping back in time. The fear hit me again, and I was just so suffocating. And I had a really difficult time getting through that. I didn't want to leave the house. I didn't want my kids to leave the house. But with the help of my family, and especially my husband, we got through that time. And it really helped knowing that he was living more than an hour away in a Boston shelter. I frequently checked the sex offender registry to make sure he hadn't moved, and got through the period. Then last year, I learned that my rapist died of natural causes. And Although I don't want to celebrate someone's death, I can't even explain what a relief it was, knowing that he could no longer find and harm me or my family. But I still fear that some other stranger may do the same thing to me or to someone I love. So I'm sure you can understand why I struggle to see how this rapist was allowed out on bail for his first rape, considering how dangerous he was. If the prosecutor had been able to appeal his bail, I wonder if my violent sexual assault and the others could have been prevented. The passing of this legislation is very important to me, as is my hope it will ensure that dangerous people are not out on bail and able to harm others. It's critical that prosecutors and judges have more legal tools available to keep our community safe. Thank you so much for letting me and everyone here tell our story and share our views.
Okay. I want to just say, you ladies are amazing. It's just amazing. Anyways, let's get it together. So, before I start, I just want to say my abuser, I got him into the courts. I was able to get him as a second sex offender, 5 years on anklet, and he was supposed to do 2 years in jail, but he didn't. He was now reduced to 6 months, and he didn't. Then a lady judge, from 6 months after my plea, gave him 3 months. He didn't do that either. He served 2, and that's disgusting. That's what I'm trying to put across. So with that said, I want to thank Jen Anderson for getting me here and putting up with my crap all these years, because it's been 5. With that said, my name is Sandy. I'm 52 years old, and I have owned my business for 30 years in a small town in the Brookfields. I'm also an active in our community extremely. Over 5 years ago, I was involved with a man who lived with me in my home for 2 years. I was much more established with career, money, and friends compared to him. He became very jealous of me and of my success. I ended the relationship multiple times trying, and I kept trying to fix this, but it just didn't work, and you'll see why. After the breakup, a man I know from town, I didn't really even know him, he's on my Facebook. He just knows me from town, of my face. He came and said that I need to see a site. I'm on it, and I don't take pictures of anything about me, of anything prerogative, nothing. I've been hurt when I was a little girl. I would never allow anybody to hurt me. So anyways, with that said, it was called myex.com. My life was turned upside down when I came to the site and saw it was me. And this is what I saw. He has drugged me, and you can call it sexual abuse, but that name, sexual abuse, is used very flimsy. It's called rape, if you all want to put it in the nasty terms. That's what it was. But nobody wants to hear that, so, okay. So I came to see that, and I noticed he had posed me very nasty ways, naked, and extreme nasty, so you can get what I'm saying when I say nasty. It was nasty. Without my knowledge, and the picture shows that as well. I posted these horrible naked pictures online with an offensive message about me, my ex-husband, who I am best friends with, by the way. Just jealousy. It was just jealousy. So my Facebook photo on top of it, so anybody who would see those sites would know it was me. And all was included, he said, videos are coming soon. So he had already done this multiple times. I had different clothing on, meaning undergarments, and he was removing them and the pictures and doing extremely disgusting, nasty things to me. And that's how I knew, and it was in my home. It was still in my home. He was doing this to me. And then when he said the video's coming soon, I mean, how rotten could you be? It was so, just, he planned it all. It was awful. Anyways, okay. He knew the relationship was out and it was gone, and that's when he was doing it all while we were living together and destroyed me. That was his goal, was to destroy me. The revenge posting viewed. Now he put me on this site called myex.com. 30,000 men seen me. 30,000 saw all the rotten, nasty, private things that he was doing to me. So disgusting, they commented and rated it. I was devastated. I was diagnosed with post-traumatic stress, everything. I mean, I went from here to there. It was horrible. I never could imagine a man that I loved, who claimed to love me, could do this out of retaliation for ending a relationship. He tried to destroy me publicly and my business and my reputation and emotionally. I will never be the same again, and I'm not. I do not trust men. So I cried for 2 years every day. I had one officer, Christopher Domaze. He was amazing. He kept checking on me. Why, I don't know, because I just felt nobody cared anymore. But he did. I almost lost my business and my life because I was giving up. I became a victim. I had no voice. And I'm going to tell you, the courts did shit. They did nothing for me. They tried, but they didn't. There was no law. And because all he was a landscaper, and they kept letting him out, letting him out, letting him out, letting him out. Oh, he has a job to do. Well, so don't I, but yet I can't do it because my life is falling apart, and half of the world just see me. Again, not half the world, but 30,000 and a man and officers in my town saw me. Awfulness. Something that nobody should see nor go through. Again, I'm sorry. So, like I said, I almost didn't make it. So, he is the abuser. He had more rights than me. Everybody, even though he admitted it to the officers what he did, it didn't matter. I still had to prove what? He did it. I was unconscious. What am I supposed to prove? But I still had to do it. So this is a traumatizing time for me, and no woman deserves to go through this. We feel ashamed for something we didn't even do. We're hurt, and I felt defeated. The personalized situation is just so important that victims, gosh, we have rights. Our lives matter. They really do matter. We are the woman. We populate this world. We do matter. And nobody deserves to be put through this crap. Thank you for listening. I'm so sorry. Thank you, amen.
Now I'm going to read for KM. 14 years ago, MySpace was the primary source of social media for teenagers and young adults. Social media now consists of Facebook, Instagram, Snapchat, TikTok, and all other kinds of technology with much easier access and decreased user effort. As a young teenager growing up with the emergence of social media, I never expected to be known as the naked picture girl in high school. A classmate had convinced me to send him naked pictures, luring me in by the promise of being his girlfriend one day. As a freshman in high school, I was convinced and seriously naive that he was the one for me. I wanted to do everything I could to be his girlfriend, so I sent him naked pictures. A few days later, he had manipulated me into meeting him in person. He showed me he still had my pictures on his phone, even though he had promised he had deleted them. After he sexually assaulted me and told me not to tell anyone, a few weeks passed since the sexual assault, and I finally caved. I told a friend what happened, and word got back to him, and as revenge for telling someone, he distributed my naked pictures through email, MySpace, and Facebook to multiple friends. They, in turn, sent them to what I felt like everyone and anyone. The pictures were even printed out and brought to school. My classmate was not charged with dissemination of child pornography, even though there was a seriousness in what he had done with malicious intent for revenge. He was allowed to continue to be at school, manipulating other girls to perform sexual acts with him. I was told I would be the one to be prosecuted for dissemination of child pornography, not my abuser. I was already embarrassed and devastated, but I didn't need to be re-victimized again with being persecuted by the court. I needed cognitive behavioral therapy and dialectical behavioral therapy to understand the seriousness of sending naked pictures out in the first place. I needed help in understanding my worth and value as an adolescent. I needed to help to improve my self-esteem, confidence, and anxiety. As a professional with a bachelor's degree in psychology and a minor in sociology, with 6 years' experience working in mental health, I can attest that trauma is long-lived and persistent unless addressed immediately following the traumatic event that has taken place. To this day, I have very few friends. I have significant anxiety being near or around the town I grew up in, and always wonder if everyone sees me as the naked girl picture, 14 years later. I am in full support of making the laws surrounding sexually explicit materials to be more spectrum-like. The law needs to keep up with the demand and easy access to social media today, as there is a significant difference in disseminating child pornography, like in my situation, versus sending Snapchats out to all your friends and not realizing you're breaking a very serious law made for adults, not adolescents or children. Diversion programs should be implemented for cases with less serious intent, but to be taken more seriously when vicious, revengeful, and malicious dissemination of child pornography occurs. I thank you for your time. And with that, I would like to thank everyone here, and I would like to thank all of you for bringing and sharing your stories and using your voice and raising your voice for those who aren't able to use their own voices. And that the legislation, your stories have pointed out how vital both pieces of legislation are for the safety of survivors, and to have your voices heard and to be acknowledged and validated when you speak up. And that I hope that today in your stories, your voices will be heard and there will be action. I would like to turn the floor over to Governor Baker for closing remarks.
I wish we didn't have to have this conversation today, but we do. And I want to thank each one of you for bringing your personal stories forward. This is not television, this is not a movie, this is real. And while the event or collection of events in your life in some ways and for some of you, are past, that experience is with you forever. And for those of you who have children, and the trauma for them is a painful experience for you as well. You worry for their future. We needed to do this because the laws have to change in the state in order to better equip the courts and our judges and all of the people within the system who administer justice in this Commonwealth have the tools they need at their disposal to be able to make better decisions. This, to us, is reasonable, it's leveling a playing field, it's common sense, and it needs to be prioritized. On the dangerousness statute, as well as bringing our laws into the 21st century, knowing that technology is available and that with social media and connection to the world through the internet, we must increase the penalties for those who are taking advantage and without your consent, in some instances, using something against you. And also equipping our children with what they need to understand in terms of the consequences of their behaviors, and some of it might be innocent and not fully aware of what their actions are as teenagers. And then for those who are exploiting intentionally, that there is a real consequence. And it strikes me, for a state where we are so progressive and leading in so many ways, that if 48 other states have laws relative to revenge porn, then why are we waiting? And why are we putting more people in harm's way without having a felony consequence for utilizing a sexually explicit visual image without your consent, to harm you, to hurt you, to harass you, to embarrass you? And much of this does come out of relationships that exist or relationships that never existed. And I'm hoping that with the refiling of this, it's not the first time we are refiling this bill, that with your voices, this is what it will take to change the laws and improve the safety for not only you, but for others here in this Commonwealth and for our children.
Your courage, not just today, but every day, is breathtaking. There's nothing worse that I can think of than not knowing what the next day may bring. And for all of you, it is so clear, first of all, that you never know or knew what the next day would bring. And secondly, that those in public life who are supposed to be there to protect you and to provide you and your family with some peace of mind did just the opposite. Now, we filed this legislation, both bills, 4 years ago. And I have to say, I've never been so distressed about my incompetence and my inability to actually deliver for someone as I am right now. Because I know how many people you speak for here in the Commonwealth. And I know that in other states, they have a framework that provides you with the support and the protection that you don't just deserve, you're entitled to. I literally wrote in my notes, I sometimes wonder whose side we're on. This issue with GPS devices is not new. This issue, as Lieutenant Governor said, with sexually explicit materials is not new. The stories that you've told are yours and yours alone, but again, they're not new. People in a position to do something about it have heard these stories, and yet they continue. I am so grateful, and I know I speak for the Lieutenant Governor, for the Secretary, and for the rest of our team. You are willing to be here today and to put your life in front of these very boring words that represent statutory reform. Because in the end, they're just words on a piece of paper. It's your life and your stories and the people you speak for that I hope will move our Commonwealth to do the right thing, not just for you, but for so many others like you who deserve a lot more than you've gotten from your government. Thank you.
Thank you.
Wanna go?
You did awesome.
Just turn around.
Huh?
Just turn around.
So first of all, I just want to start by thanking Sandra and the folks who had an opportunity to share their stories with us today for joining us. I couldn't help but think as I listened to those stories that sometimes I wonder whose side we're on. And I really do hope that this year, in this legislative session, we have an opportunity to do the right thing by so many people who have been done so wrong by our judicial system. The proposals that we're filing today would provide comprehensive and new protections for survivors of crimes like domestic violence, assault and battery, sexual assault, and the harmful distribution of explicit images. I can't tell you how grateful I am to the survivors who joined us here today, and to the domestic violence providers and the advocacy organizations and the others who speak so eloquently and urgently to the why with respect these reforms are necessary and deserve to be enacted into law. The people who shared their stories made quite clear the havoc that the inaction of the Commonwealth has wreaked on their lives and their families. And in many cases, the procedures by which the court system deals with these individuals fails to provide them with the protection and the peace of mind that they deserve. These stories reiterate the conclusion that we made several years ago that the existing limitations on the current system when it comes to pretrial detention and all the laws with respect to sexually explicit materials unnecessarily expose victims to potential continuing and future harm. To put simply, a prosecutor must either seek a dangerousness hearing during the defendant's first appearance in court or forfeit that ability entirely, which, among other things, ignores the possibility that circumstances may arise after that first court appearance that would conclusively establish that that individual is in fact a danger to someone else or to the community. Our bill also aligns pretrial detention statutes with a common sense understanding about how criminal behavior poses a danger to the community members generally. A person alleged to have committed an indecent assault and battery on a child, for example, or a statutory rape is not currently subject to the dangerousness hearing statute as it exists in Massachusetts. And as several of those stories made perfectly clear, a defendant's history of criminal convictions is also not grounds to have that hearing. It does the public little good to have a dangerousness statute that fails to protect victims from conduct that plainly puts them or the public at risk. And furthermore, the current statute only provides for protection for a defined period, as several of the victims and survivors spoke to earlier, rather than until the disposition of the criminal charges. A person who's so dangerous that his or her release threatens the safety of a specific victim or the community at large does not become safe to release simply because 3 or 4 months have passed since the time of their arrest. Our legislation would ensure that dangerous crimes are not exempt from a dangerousness hearing and that a dangerousness detention lasts until the underlying criminal proceedings are complete. Many of today's survivors also have stories that relate to GPS monitoring devices for dangerous people who are eventually released. Our bill would recreate a new felony offense for cutting off a court-ordered GPS device. When a person's arrested and released on pretrial, victims and other members of the public should be able to rely on those conditions for protection and to trust that there will be consequences for a defendant who violates them. Several of our survivors who spoke today demonstrated that the current state of affairs is broken. The bill we're filing today improves that system for notifying victims of crime of abuse and other dangerous crimes when a defendant is going to be released. It also empowers police to detain people who they observe violating court-ordered release conditions. And current law does not allow this, and instead requires a court to first issue a warrant. But it is our police officers and our judges and our probation officers who are on the streets of our cities and towns and who are in position to see and to act when offenders are violating conditions of release. The bill authorizes judges to revoke a person's release when the offender has violated a court-ordered condition, such as an order to stay away from a victim or from a public playground. Current law requires an additional finding of dangerousness before release can be revoked. In addition to those provisions, a new provision in today's legislation would also enhance the collection and value of data for the cross-tracking system required by state law by ensuring that information about an individual who is arrested or arraigned can be linked to a unique fingerprint identifier. With these and several other changes, this bill would make substantial improvements to the loopholes and the procedures by which our criminal justice system currently deals with dangerous people and would dramatically improve our ability to protect survivors and their families. Many of these changes may look at first glance like technical changes to court and law enforcement policies, protocols, and procedures. But nothing could be further from the truth. These changes would, in fact, dramatically improve the system's ability to protect and support survivors and victims, which should, in fact, be a major focus of our work here in Massachusetts. They would have a real-world impact for people who've experienced, and I don't need to explain to anybody here what that means, significant trauma and have been the victim of terrible crimes and prolonged abuse. We owe it to them this time to make these commonplace reforms during the course of this legislative session, and I certainly urge the legislature to move forward and make this happen. And now I want to turn the podium over to the Lieutenant Governor, who in her role is the chair of the Governor's Council to address sexual assault and domestic violence, is a leader on these issues, and will speak to some of the other components of what we're filing today. And thank you again to the victims and survivors for your testimony.
Thank you, Governor, and thank you all for being here this afternoon. I wish to just begin by thanking our partners in law enforcement and the Executive Office of Public Safety. I wish to thank Kelly Dwyer, who's the Executive Director of the Sexual Assault and Domestic Violence Council. I wish to thank Lori Myers, who plays several roles, one at the Sex Offender Registry Board, but also as a leading voice for community voices of survivors and victims here in our Commonwealth for many years. And I wish to thank Representative Sullivan for leading the exchange of information and the sharing of stories today, and for being outspoken as a member of our legislature on these important matters. As a woman, as a mother of teenagers, and as the chair of the Sexual Assault and Domestic Violence Council, I am pleased that we are refiling these bills. Oftentimes people think we refile a bill, well, just to refile. Maybe it's not that important because it didn't get done the first time. We're refiling this set of bills and changes to our laws because it's critically important that we get this right here in the Commonwealth of Massachusetts. And we, as leaders in this area, need to do a better job, frankly, of telling the legislature and the community at large why this is important. And I want to thank each one of you, each survivor, for coming forward today and for sharing your story with all of us and for helping us literally get these changes over the goal line here in the Commonwealth of Massachusetts. The things that I've heard before said and I've heard again today: living in the fear of death, living in the fear that you could be harmed, living in the fear that your abuser could be around the corner in a random place, living in fear that a GPS monitoring device, which the court thinks will provide you with that protection under a restraining order, could be cut and disarmed, living in fear that your children will will be traumatized once again, and what that means for their future is what this is all about. And we know that we have tools that will change that. Holding perpetrators and abusers accountable is a key piece of how we better protect you as survivors and victims and prevent this from happening to others. This must change, and the governor outlined in quite some detail what those changes would be to the dangerousness statute. It's clear that in a day and age where electronic devices and social media and the internet are integrally involved with how we live our lives, that we here in the Commonwealth of Massachusetts, the most innovative economy in this country, needs to get up to speed with changing its laws relative to the exchange of sexually explicit visual materials. You heard about a teenager, and the mother of 2 teenagers, whose image was shared with her classmates in her school, in her community, and 14 years later, it feels like it was yesterday. That can be changed. This update to our laws would better protect children. First of all, it would create, as a requirement in our school districts, a cyberbullying curriculum that is most suitable to that community. We need to do that. We need to amplify the Respectfully campaign and prevent and make aware to children what is appropriate, what is not, what is toxic, what is healthy, and better prepare them for their future. It will also create, for the district attorney's office, more flexibility around diversion. We have diversion courts for a number of different things here in the Commonwealth, and they work. And in this case, if a sexually explicit images case comes to the courts, it gives them the opportunity to divert that matter, if appropriate, for children, for youth to become better informed and engaged around what is right and what is wrong. But it also gives the courts the discretion to decide whether it is something more than an educational fix, and whether an individual should be prosecuted as a minor for a misdemeanor or something more. And that is something that our district attorneys agree with and want to see happen here. It's unanimous support for this. And it would also change the laws relative to adults. And you heard about a case of an adult relationship that changed, and the images of this person shared literally with thousands and thousands of people around the world. And that case, there should be significant consequences for that. There should be a felony law on the books of the Commonwealth, like 48 other states, to make sure that that individual is held fully accountable and to prevent that person from doing it to someone else. And here in the Commonwealth, we can do that if we update the laws in that way. I just want to say thank you once again, and that as we leave here today, leave here feeling empowered and leave here feeling a sense of responsibility. As the legislative clock continues to tick, it is an abbreviated year next year, and we have a relatively short period of time to get before the legislature, to share this information, and to change the laws to better protect our citizenry here in the Commonwealth of Massachusetts. Thank you.
Questions? I don't really know what the hesitation was. I think Massachusetts has always prided itself on being a progressive and fair and just community when it comes to its laws, especially when it comes to laws that involve aggression and violence and assault on women. And I think in this particular case, people had a chance to hear today that our laws are failing many, many people in these circumstances, and it's time they get fixed, and we're going to work very hard to make that happen. Well, just to speak to the stories that we heard earlier, the fundamental problem with our current statutes with respect to the whole question of dangerousness really derive from the fact that in Massachusetts, a district attorney has 1 day to seek a hearing for dangerousness. And if other information becomes available or other circumstances prevent themselves, they miss the opportunity. It's gone. And I think in this particular case, we would argue that what you simply need here is a broader definition of what should in fact be. I think sexual assault on a child should be considered something for which you could ask for a dangerousness hearing. I think you'd be pretty hard pressed to find anybody in Massachusetts who doesn't. You currently can't, and that one's been vetted by the Supreme Judicial Court of Massachusetts. You can't. And with respect to many of these other issues, this is a procedural question, and it's an easy solve that would simply give district attorneys the ability to pursue a dangerousness hearing based on information as it becomes available, as it relates to the defendant, as it relates to the accused, and as it relates to the circumstances in the situation as it evolves. You currently get 1 day, 1 shot, that's it. That's a bad way to make law, especially in situations like the ones we heard discussed previously, where these folks were continually abused and assaulted and terrorized over a significant period of time for which nothing happened. So I would say a couple things about the holidays. One is we did distribute 2 million rapid tests to the 102 communities here in the Commonwealth that were hardest hit and had people with less means to be able to purchase their own rapid tests. And we hope and anticipate that our colleagues in local government, as those 2 million rapid tests get distributed, and they're being distributed all week, will make those available to people in their communities. It's very important that people get tested before they go to the event, okay? One of the things that's been important for me to point out is we have a lot of people who go to our test sites on Mondays and Tuesdays, which means they went to our test sites after they went out on Friday and Saturday. What we would say to everybody as we head into the holidays is take advantage of these rapid tests. If you can get them through your community, go for it. You can get them at CVS, you can get them at Walgreens, you can buy them online. Or you can go to one of our test sites. We do 100,000 tests a day here in Massachusetts. But it's very important for folks, if they want to protect themselves and their family members, especially their elderly or vulnerable family members, get tested before you go to that event. And if you test positive, take it seriously, isolate yourself, and test until you test negative. But waiting until afterwards in some respects, well, I certainly appreciate why people would do that. The better strategy here is to test in advance. Yep. Yeah, we have hundreds of locations around the Commonwealth where you can currently get boosted, and we're deliver booster shots, and we have about 1,500,000 people in Massachusetts who are getting booster shots. Thank you very much if you're eligible for doing that. We're probably delivering somewhere around 30,000 booster shots a day. Having a site open up at Fenway, and we appreciate the Red Sox support. It's obviously a high-density, high-population area, and we expect and anticipate that that will help us significantly enhance our booster capacity once that site gets running. And thanks again to all of you for being here and for sharing your stories. And Sandra, thank you.